Last week, an application by Dr Nandipha Magudumana to have her arrest in Tanzania declared unlawful was heard in the Bloemfontein High Court. Advocate Anton Katz, Magudumana's legal counsel, argued that there was no deportation process. They believe it was an extradition and not a deportation, and if indeed the court does find that initial process unlawful, then it would mean everything preceding that should thus be declared unlawful. The respondents to the application, the Home Affairs Department, the police services and the NPA, believe that all due process was followed in the arrest and in returning Magudumana to South African soil. Well, judgment is set to be delivered tomorrow, and for more analysis on this, we speak to legal expert Melusi Xulu. Melusi, thank you so much for your time, and thank you for joining us on the Weekend Report. I want to start with that point that we made in that introduction, the fact that it has been argued by Nandipha Magudumana's lawyers that what happened in Tanzania was in fact an extradition and not a deportation, based on how much these two countries collaborated together to get the pair back on South African soil. What's your response to that?
Okay. Firstly, good morning to you and the viewers at home. Thank you for inviting me. Well, the argument of the representative of Dr. Magudumana is that the deportation that is stated by the Department of Home Affairs was actually a deportation that is disguised. There was actually an extradition that is disguised as a deportation, in this sense that, well, if you look at the definition of extradition, just in general one, is that it's where there's an agreement between two countries that when there's a fugitive in another country, the one country can request that that fugitive is brought back to the country or where he escaped from or she escaped from for the purposes of a trial. So they are saying, due to the fact that there was a collaboration and an agreement, that gives rise to what is essentially an extradition. And then obviously the state has to respond to that, to state clearly what happened, because one of the other issues she raises obviously is that she was abducted and that the South African police services were the ones who were involved in her arrest most of the time. So I think that is what they are trying to place there. And what I want to highlight here in all is this, and it's a question. Did the overzealousness of the South African officials, namely the South African Police Service, not influence what Dr. Magudumana is trying to say? Did it not influence them maybe not respecting the sovereignty of Tanzania, so to speak? Maybe that's what the judge must decide on when he decides tomorrow. But I'll come back to the response of the state's representative. Right.
Well, the Department of Home Affairs is insisting that, the arrest itself was effected by Tanzanian officials on Tanzanian soil, as would be any sovereign right of a country to do so. They would have that jurisdiction. Furthermore, just in terms of immigration laws, the pair of them, their papers weren't in order. So in terms of immigration law, they were also on Tanzanian soil illegally, and there was a warrant of arrest that had been issued for the pair of them. And so I wonder, whether or not it wouldn't have also been wise for Magudumana's lawyers to have Tanzanian authorities added as respondents to the matter, because we certainly need to hear the Tanzanian story, statement of facts from Tanzanian authorities themselves as to what really happened the day that arrest was effected. What do you make of that?
Okay. Firstly, Tanzania is a sovereign state with its own laws and rule of law. So the warrant of arrest, which is in terms of Section 43 of the Criminal Procedure Act in South Africa, it was only applicable to South Africa, so it could not go beyond the borders of South Africa. But let's look at what Tanzania says it has done. As you've put it clearly, it maybe to hear their side would have assisted. But what they've done was, if you go to Section 26, I believe it's Section 25, subsection 2, paragraph C of the Immigration Act of 2016 in Tanzania, it says, if it's proven that you're a prohibited criminal, immigrant, they can decide to deport you without appearing before a court of law in Tanzania. And then it can be arranged that you are deported. So there was an order that was granted or that was given in Tanzania. And then it was stated that within 3 days from the 12th of April, you must leave the country. So that is what the state is saying. They are saying, no. The South African police were not involved. Only, I would say, handing over was done. And maybe that is a debate. So here's my question on this, is that does the agreement to collaborate between the two states give rise to an extradition, or was the deportation in its true form as it should have been done in terms of the Immigration Act of Tanzania? I think that's what the judge has to decide on tomorrow. Right. That's one of the issues.
It does seem a very, porous argument, Melusi, because on the one hand, we have Tanzanian officials acting out their own pieces of legislation, their own legal frameworks for immigration, the breaches of immigration laws. On the other hand, as you've highlighted, we have an overzealous South African government that is quite eager to make these arrests, and so the potential of this being disguised indeed as an extradition when in fact what was handled as a deportation is problematic. Is there any precedents for this? Are there other perhaps rulings that could help clarify this issue for the court as it handles making the differences between the two?
Okay, one of the cases which we had being quoted quite extensively was the case of Mohammed versus the South African state, where Mohammed was, there was a need for him to be arrested by the FBI in America. And one of the things that he wanted was clarification if when he's taken to America, is the death penalty going to be applicable? And because of the right to life in terms of Section 11 of the South African Constitution, it was clearly important that if that confirmation cannot be done, it was not going to be lawful for him to be taken to America. But the difference, as Advocate Van Zyl was trying to highlight in Rule 23 of the Aliens Control Act, then he said at that time it was important that did South Africa have the rights to deport him where it's not his country of origin? Because Rule 23 says this. It says if you want to deport someone to another country or take him to another country, if it's not desirable for him to be in South Africa, is that he must be taken to the country of his origin. And at that time, Mohammed was from Tanzania, quite ironically for this comparison. So I think that's one of the differences there are there. And obviously there are consent, whether she did consent. And I think that Advocate Snellenberg, forgive me if I pronounced it wrong, he said, in essence, she said that she wanted to come back to see her kids, which is what the state is saying by saying that she was giving a consent to come back to South Africa. So there are all those arguments that are brought by the respondents' legal representative.
Right. All right. So is it an extradition? Is it a deportation? Hopefully we'll have the answers from tomorrow's judgment. But something else that was brought up by Magudumana's lawyers was this idea that if indeed what was effected in Tanzania was an unlawful arrest, the implications of that for the remainder of the trial, because as we know, she is facing criminal charges in another court. And there's this whole notion that if indeed her arrest was unlawful, that should have far-reaching, ramifications for her other presence that is required in this other matter. How does that work exactly?
Okay, look, when I first read her initial papers or her founding affidavit, I wanted to find a point where she would say in one of the orders she's seeking or the relief, is she seeking an order that specifically says should she be released by this order that she's seeking, she should not be tried for these specific crimes that have been charged against her. Now that will be crucial although it's not possible, that will be crucial in this sense that should she be out, if there is a chance that she'll be out through this application that she's doing, then she can no longer be tried for this case. But the essence is that the trial or the charges will still remain. But here's how I'm seeing it being played out, and also, if it happens, the order is granted. The order is granted that the charges are withdrawn and so forth because of the arrest being unlawful, inverted commas. I believe if the state tries to maybe issue a warrant of arrest again, to bring it to court again, in a lawful manner, inverted commas, I believe she will also challenge that again, as long as she has the resources to do so. So it's going to be a long battle, and we'll see who will win the war at the end of the day, because I believe she's ready to fight it to the end. It's a case of her life.
If that's the case, then, if we're going through this entire legal process, Melusi, only to have her potentially released, if indeed her arrest is declared unlawful, then to have her rearrested by other charges that the National Prosecuting Authority then brings forward for her role in the actual escape of Thabo Bester. What would have been the point and the purpose of taking the Department of Home Affairs, SAPS, and NPA officials to court to have her arrest declared unlawful, if it could all circle back again to the fact that she had a role to play, an alleged role, at least at this point, as an accomplice in this escape?
That is why I'm saying maybe her game, maybe, should she be released and they try to bring her back, she will try, in essence, and even use what she's stating now to say she will challenge it again. I think that's how she'll do it, because here's how I see it. If she tries to apply for bail, well, before these issues that she brought up came up, if she tries to apply for bail, look, she's a huge flight risk. She's a huge flight risk. So her using the civil courts strategy, I think, is a better strategy than trying to apply for bail, because she's one of the role players, in inverted commas, in the alleged offenses that involve Thabo Bester. So I think she will try to avoid criminal court as much as she can, and seeing that she has a strong legal team, I think she will do the best that she can should she be wanted again, if she gets what she wants. So that is why I'm saying I'm seeing a long battle, legal battle that's going to play out. But at the end of the day, the trial will have to proceed. So we'll see how the state will fight to make sure that she's brought to court, because it does bring a bad reputation on the state, Home Affairs, South African Police Service, and the NPA, if at the end of the day she, again, inverted commas, she escapes the criminal trial.
All right. I suppose it will be all eyes on the Free State High Court tomorrow to hear what the judge has to say. And we'll leave our conversation there for now. That was legal expert Melusi Xulu talking to us about that ruling expected down in the Free State High Court on Dr Nandipha Magudumana's application.